Welcome back to our channel, the place where hidden chapters, royal secrets, and the stories the palace won't publish finally come to light. Today, we bring you a breaking news. Maxwell finally talks. The terrifying truth about Meghan Markle. Recent revelations linked to claims made by Ghislaine Maxwell have intensified public examination of Meghan Markle's early upbringing, implying that aspects of her history may connect with those involved in the Jeffrey Epstein case. The claims derived from a combination of court documents, confidential testimonies, media stories, and recollections from individuals characterized as insiders contest the oversimplified public narrative of Markle's pre-royal background and her introduction to the British royal family. This investigation centers on the assertion that some social connections of Markle may have intersected with individuals associated with Prince Andrew prior to her acquaintance with Prince Harry, raising inquiries regarding the knowledge possessed by various parties and the timing thereof. The subsequent research encapsulates the circulating assertions, contextualizes them within the legal and social frameworks that delineate knowledge, and examines the potential ramifications for the Duchess, the royal institution, and public discourse at large. The objective is to uphold a balanced, evidence-based stance regarding material that is still unresolved in legal and public records. Context: Maxwell redactions and sealed depositions. The new discourse mostly revolves around the availability of sealed and extensively redacted testimony provided by Ghislaine Maxwell, the British socialite jailed for her involvement in Jeffrey Epstein's sex trafficking operation. Following Maxwell's arrest trial and conviction, segments of deposition transcripts and other litigation-related information emerged publicly. However, much of the content was concealed by significant redactions. Observers indicate that a significant segment of Maxwell's oral testimony, documented by various witnesses as surpassing 12 hours in duration, remains sealed in accordance with a court order. The relationship between disclosure and concealment is crucial as it influences the public's capacity to assess claims. Redaction and sealing are standard components of the legal process employed for various legitimate purposes to safeguard the privacy and safety of alleged victims, to maintain the integrity of ongoing criminal or civil investigations, to prevent the disclosure of statements made under confidentiality, to protect information pertaining to minors, and to avert the public identification of individuals not charged with criminal misconduct who may experience reputational damage. Judges utilize discretion to weigh transparency against privacy and safety concerns, resulting in varying opinions among different courts or judges regarding the appropriate balance. The significant amount of redacted content in the Maxwell-related documents has sparked public conjecture on the information being concealed. For individuals unfamiliar with typical discovery procedures, significant redactions may suggest that critical material regarding prominent public figures has been deliberately concealed. This view is intensified in a media landscape inclined to supplement voids with speculation. In this context, the initial significant assertion connecting Markle to the Maxwell testimony surfaced. Certain sources associated with the proceedings allegedly indicated that Markle's name was included in the segments of Maxwell's testimony that were not disclosed to the public. The implications of the documents. The exact nature of any alleged reference to Markle inside the secret documents has not been confirmed in the public record. The nature of any mention, if it exists, remains ambiguous, whether it was a transient reference, a memory of a specific interaction, or an element of a more comprehensive narrative regarding events or participation in certain meetings. Reports indicate that Markle's name was included in testimony deemed too sensitive for widespread distribution by judicial officials. The purported reference has been utilized by proponents of the narrative to imply that before her association with Prince Harry, Markle may have frequented social circles intersecting with the Epstein network. The legal procedures around depositions and sealed testimony generate significant ambiguities. Depositions are conducted during discovery to establish facts and preserve testimony. Nonetheless, they may contain assertions elicited by leading questions, hearsay, or uncorroborated recollections. Judges occasionally seal portions of depositions not to validate the veracity of the substance, but to safeguard other parties' confidential sources or ongoing investigations. Thus, a deleted reference, regardless of its existence, does not inherently signify confirmed participation in unlawful conduct. It is a singular piece of information that necessitates validation through documentary evidence, supplementary witnesses, or other permissible proof. In the absence of corroboration, conclusions derived from an unconfirmed and sealed reference must be considered tentative. Meghan Markle as a possible witness in Giuffre vs. Andrew. During the pre-trial discovery phase of Virginia Giuffre's civil lawsuit against Prince Andrew, a separately documented development arose, attracting significant scrutiny towards one of Epstein's most prominent allies. In the discovery phase, both parties generally exchange papers and identify prospective witnesses. Giuffre's legal team allegedly contemplated and may have attempted to depose Markle as a witness. A deposition is a formal sworn statement given outside of court wherein a witness responds to attorneys' inquiries and preserves testimony for trial purposes. Significantly, the reported contemplation of Markle as a possible deponent was not based on any accusation of misconduct. Contemporary accounts suggest that claimants believed she may have pertinent information regarding Prince Andrew's social behaviors and affiliations during the examined period. As an actress engaged in environments that occasionally intersected with world elites and prominent events, Markle may have had memories of overlapping groups. In civil discovery, attorneys typically broaden their search to uncover potential witnesses with relevant testimony. The inclusion of a celebrity on a witness list frequently signifies the extent of the investigation rather than an assertion of the individual's centrality to the case. The criteria for requiring a third-party deposition are dictated by civil procedure regulations and judicial monitoring, necessitating a balance between relevance and the constraints placed on the witness, as well as privacy concerns and the risk of harassment. Counsel frequently negotiate restrictions on the scope, scheduling, or format for prominent witnesses. The royal family and representatives of Prince Andrew faced challenging considerations regarding the possibility of Markle giving sworn testimony in a prominent legal case. A deposition could have exposed her to rigorous questioning about previous social connections and any awareness of Prince Andrew's behavior, a level of scrutiny that many wish to evade. Ultimately, Markle was never interrogated under oath. The Giuffre v. Andrew case was resolved out of court for an unknown amount before to a jury trial, eliminating the necessity for further depositions. Nonetheless, the alleged inclusion of her name in discovery processes is still referenced as adding procedural significance to the overarching narrative of potential closeness to that environment. Accusations associated with Maxwell the Flower nickname. While incarcerated, Maxwell reportedly claimed familiarity with Meghan Markle from her formative years as an aspiring actress, asserting that Markle was referred to by the nickname Flower within select private circles. These unverified accounts suggest that the moniker was not a public or professional alias, but rather an informal designation utilized by a limited group attending exclusive events, some characterized by sources as adult entertainment venues and social networks associated with Epstein. Individuals conveying Maxwell's purported statement assert that Flower was present on guest lists and utilized in private discussions among attendees at parties, yachts, and other exclusive gatherings. Proponents of the claim suggest that Markle was not just a casual observer, but had a discernible presence, albeit somewhat marginal, within a social environment that for many onlookers would starkly contrast with the public persona she ultimately adopted. If accurate, this relationship would redefine elements of her journey. Instead of a Hollywood actress who serendipitously entered a royal romance, she would be perceived as somebody who adeptly maneuvered a more intricate and subtle social milieu. Researchers and reporters examining the Epstein network often highlight the employment of coded language aliases and various sorts of caution designed to conceal activities and affiliations. From this viewpoint, the purported existence of an alias for Markle may be perceived by some as an indication of assimilation into a domain that functioned under its own regulations and intentionally concealed from public scrutiny. It is imperative to emphasize that the source of this allegation regarding Maxwell is a convicted felon, and no independent on-the-record verification documentation proof or publicly authenticated guest lists have surfaced to validate it. Nevertheless, the dissemination of the assertion has significantly heightened public interest in aspects of Markle's pre-royal existence that remain obscure. Analyzing social circles, Prince Andrew, Sarah Ferguson, and elite networking. To comprehend the origins of these ties, it is essential to examine the recorded social circles of Prince Andrew and his ex-wife, Sarah Ferguson, during the 2000s and early 2010s. Prince Andrew's connections with Epstein and Maxwell are well-documented photographs. Travel itineraries and other records indicate instances of his presence alongside Epstein and Maxwell, including journeys on Epstein's private jet and visits to locations associated with him. These recorded contacts were important to the subsequent examination and legal disputes. Accounts positioning Markle on the outskirts of numerous social circles depend on a credible social mechanism, as a professional actress pursuing career progression. Markle would have participated in industry gatherings, philanthropic events, and private functions environments where networking and introductions to prominent individuals are customary. The assertion is not that she was an intimate confidant of Prince Andrew, or that a love relationship occurred. Instead, the argument is that she was present in the same venues and at concurrent occasions, where influential individuals frequently interacted. In elite networking, proximity is significant. Introductions may be intentional strategies or unintended consequences of professional engagement. Advocates of this perspective propose that during this period Markle may have been observed by individuals associated with Prince Andrew Maxwell or Epstein. When analyzed retrospectively, such sightings can be regarded as circumstantial evidence of acquaintance. Sarah Ferguson's involvement in that network is referenced in narratives indicating more profound associations. It is publicly documented that Epstein made a contribution to Ferguson at one time to assist in settling debts, an incident she subsequently described as a failure of judgment. Similar to Prince Andrew, Ferguson navigated global spheres of influence and cultivated associations with affluent individuals and socialites. The widely acknowledged timeline suggests that Ferguson and Markle met just before Markle's engagement to Prince Harry. However, many insider sources dispute this chronology, claiming that Ferguson was acquainted with Markle prior and that their social circles intersected. These sources assert that they participated in similar gatherings and had mutual acquaintances, suggesting potential rivalry with Ferguson, allegedly seeking to restrict Markle's access to specific individuals, including Prince Andrew, as Markle's prominence increased. The motivations behind such efforts, if they indeed took place, remain speculative, whether they were driven by protection rivalry or a desire to control social capital. These reports suggest that Ferguson may have had prior and more profound knowledge of Markle's past than has been publicly recognized. Soho House Ron Burkle and the dynamics of introductions. The often recounted origin narrative of Markle and Prince Harry's encounter is that of a serendipitous blind date orchestrated by a mutual acquaintance. An alternative account highlights a significant event occurring almost a year prior to their officially acknowledged initial date, the inauguration of a Soho House pavilion in Istanbul in April 2015. Soho House, a consortium of exclusive members' clubs and lifestyle establishments, fosters a selective membership of artists, celebrities, business leaders, and media professionals. The group operates as a selective networking venue where professional connections are established and introductions to prominent individuals frequently occur. Ron Burkle, a billionaire investor and philanthropist, was a notable figure inside the Soho House network, renowned for his broad connections in the entertainment, political, and financial sectors. Burkle has been a benefactor of Soho House establishments and is frequently characterized as having influenced elements of that upscale social milieu, either directly or indirectly. The Istanbul opening attracted an international array of participants, and coincided with formal visits by members of the British royal family, including Prince Harry and Prince Charles, who were in Turkey for the Gallipoli centenary commemorations. Markle allegedly participated in segments of the multi-day event. Despite the official account asserting that Markle and Harry did not encounter each other at the Istanbul event, certain commentators and insiders propose that the environment facilitated potential discreet introductions and that the social connections leading to their subsequent meeting in London may have originated in such venues. The implication is not necessarily of orchestration, but rather of conventional social capital venues. Patrons and common friends serve as gatekeepers, and access to managed environments facilitates introductions among otherwise unconnected individuals. Rebranding swift progression and the issue of support. In the subsequent months and years following Markle's introduction as a royal consort, onlookers remarked on a swift transformation in her public image. She transitioned from prioritizing acting credits to concentrating on humanitarian causes, activism, and refined global participation. The rapidity and magnitude of this transition have led some critics to speculate that covert influences may have facilitated and expedited her public rebranding. Critics of the conventional romance narrative argue that influential persons identified Markle's potential and may have facilitated her emergence on the global arena. Within that interpretive framework, the redactions in Maxwell's deposition are perceived by some not solely as steps to safeguard victims or the integrity of other investigations, but as procedures that could conceal influential individuals who may have contributed to Markle's ascent. This represents a transition from established legal practice to speculation. Although sealing can legitimately safeguard privacy and ongoing investigations, it is a distinct and more robust assertion to claim that sealing systematically shields influential individuals whose reputations would otherwise be jeopardized. Differentiating among these alternatives necessitates supporting evidence which has not yet been presented in a publicly verifiable manner. Institutional ramifications, monarchy reputation, and familial discord. Reports from multiple sources indicate that these charges and contextual observations have led to a significant division among the royal family. Reports on the discord between Prince William and Prince Harry often depict their estrangement as stemming from personal conflicts, differing priorities, and the repercussions of the Sussexes' choice to withdraw from full-time royal responsibilities. A supplementary institutionally focused viewpoint reconceptualizes the distinction as grounded in self-preservation. From this perspective, Prince William, heir apparent and guardian of the monarchy, has embraced a resolute stance on any lingering connections to the Epstein network, motivated by a commitment to safeguarding the monarchy's public image. This explanation asserts that William perceives the monarchy's legitimacy as crucial for its survival, and is thus intolerant of ongoing public associations with individuals involved in the Epstein affair. Consequently, reports indicate that Prince Andrew has been predominantly marginalized from official duties. Sarah Ferguson retains a more ancillary public role, and Meghan Markle is perceived by proponents of this perspective as a figure whose purported history may pose a reputational liability that the institution cannot easily withstand. An much-referenced incident allegedly transpired at Balmoral Castle when Prince Andrew attempted to attend a family church service, prompting Prince William to reportedly make an ultimatum he would abstain from participation if Andrew were in attendance. Andrew's absence was interpreted by critics as indicative of William's resolve to eliminate Epstein-era affiliations from the monarchy's public image. From this institutional perspective, William's hesitance to reintegrate Meghan into the royal inner circle is depicted not solely as personal animosity toward his brother's wife, but as a calculated decision to reduce reputational damage. The heir contends that he is safeguarding the institution, questioning the monarchy's ability to endure further scrutiny from contentious associations, even if such associations are peripheral. In that context, Meghan is portrayed as a tangible connection to a segment of social life from which the palace has invested considerable political resources to dissociate itself. Locations, evaluation, and yachts, the operational dynamics of elite networks. Narratives regarding Markle's initial entry into elite society frequently reference exclusive venues, invitation-only events, and yacht gatherings. Yacht parties and exclusive marine events have traditionally served as avenues for leisure and networking among the affluent. They offer seclusion and an environment free from public observation, facilitating introductions, negotiations, and social assessments. Sources depicting such scenarios characterize them as settings where participants are evaluated, endorsed, and occasionally chosen for admission into more exclusive organizations. In narratives featuring the boat motif within Markle's early journey, a young woman at an opulent gathering transcends mere attendance. She is assessed by persons whose endorsement can facilitate access to other networks. Within that narrative context, the purported nickname Flower reportedly originated as a private shorthand on guest lists and in discussions among participants. Proponents assert that if such a scenario occurred, it would illustrate an informal vetting process, regulated by implicit standards, mutual favors, and transactional relationships mechanisms that can over time delineate an individual's social and professional prospects. Assessing the aggregate story. Proponents contend that the aggregation of allegations and interpretive assertions such as the reported appearance of Markle's name in redacted testimony, her potential consideration as a witness in the Jufer litigation, Maxwell's purported use of a nickname, and indications of prior social connections with individuals in Andrew's circle depicts a significantly different narrative of Markle's pre-royal existence than the oversimplified account commonly circulated. Collectively, these features illustrate a history more intricately connected with spheres of influence, secrecy, and elite networking than the public narrative permits. Evaluating the credibility of such accumulating story necessitates continuous focus on evidentiary criteria. Each assertion is based on unique types of source material, confidential testimony, media stories, purported insider accounts, and possible third-party documentary evidence, such as guest lists or travel records, and necessitates independent verification. Unverified associations may appear credible when presented in a cohesive narrative, particularly when the public harbors suspicions that affluence and privilege conceal misconduct. However, coherence by itself does not constitute evidence. Responsible inference necessitates distinguishing hypotheses from confirmed facts and regarding circumstantial connections as indications to be tested rather than conclusions to be accepted. Constraints of public documentation and accountable deduction. Numerous assertions remain unsubstantiated and in certain instances originate from sources with questionable agendas and reliability. A segment of the reporting relies on declarations from individuals found guilty of offenses. Extensive redactions in judicial papers create significant information deficits, and in the absence of verified evidence or on-the-record validation, conjecture is likely to abound to occupy the void. The monarchy faces ongoing vulnerability due to these unresolved issues. A segment of recent institutional history continues to adversely affect its public image, and individuals linked either directly or indirectly to that segment are central to discussions regarding reputation, trust, and the boundaries of institutional tolerance. Until sealed records are disclosed, redacted sections are elucidated, or reliable witnesses present verifiable testimony, the aura of speculation that sprang from murmurs within a prison cell will certainly continue to be a prominent aspect of public conversation. The prudent course of action is to meticulously differentiate between verified facts and claims, acknowledge the valid applications of legal confidentiality in safeguarding victims and legal proceedings, and adopt a balanced perspective towards rumors from disputed sources. More definitive answers will only be attainable through confirmed documents or credible first-hand reports. Possible pathways for enhanced clarity. Various procedural and evidential avenues could theoretically diminish uncertainty. Judicial reassessment of sealing orders via motions from media entities, concerned parties, or appellate scrutiny may occasionally result in partial or complete unsealing when public interest supersedes privacy considerations. Although restricted regarding sealed court records, freedom of information channels may produce pertinent government-held papers. Civil litigants who reach a settlement may willingly disclose sealed exhibits under confidentiality agreements, or subsequent civil or criminal proceedings may reveal corroborative evidence. Independent investigative journalism that complies with stringent standards of verification may also reveal documentary evidence such as photographs, contemporaneous guest lists, travel logs, or credible eyewitness accounts that either substantiates or contradicts particular claims. None of these options is assured, and each must be evaluated against valid privacy and safety considerations, especially where alleged victims or kids are involved. Judicial sealing justified on the basis of safety should not be revoked casually. The conflicting values of transparency and protection render this a legally and ethically intricate domain. Wider ramifications, and the argument for meticulous public discourse. Beyond the specific inquiry of Markle's actions, the overarching concern pertains to how institutions manage reputational repercussions when elite networks are shown as environments that facilitated abuse or dubious conduct. The Epstein case implicated not only specific individuals, but also the overarching systems through which wealth access and discretion may conceal misconduct and hide accountability. This lesson pertains to how institutions, corporate, nonprofit, and constitutional, organize vetting social access and reputational risk management. For the public, determining credibility necessitates vigilance regarding source quality, an understanding of how legal procedures provide limited records, and a rejection of the notion that lack of information equates to evidence of guilt. Journalists and academics must engage in meticulous sourcing verification and careful framing that recognizes ambiguity. Monarchies and analogous institutions necessitate rules that equilibrate loyalty with public responsibility and establish explicit norms for representation when associations with contentious networks are claimed. Final analysis. The fundamental question transcends a mere examination of Meghan Markle's actions and delves into her observations and knowledge. The distinction is significant both legally and ethically. Knowledge or witness testimony does not equate to blame, and public people may be addressed in manners that do not imply misconduct. Until confidential records are unsealed, censored sections are elucidated, or reliable witnesses provide verified testimony, the ambiguity originating from statements made within a prison cell will endure in public discourse. The correct approach for the public and for responsible journalism is to meticulously differentiate between verified facts and claims to acknowledge the valid applications of legal confidentiality in safeguarding victims and legal proceedings, and to maintain a stance of prudent skepticism based on stringent evidentiary criteria. Definitive answers can only be attained by credible documents or direct testimonies. Thank you for watching the video. Please let us know your thoughts and goodbye for the time being.